court does appoint an attorney to represent your child. That attorney's job is to represent what your child tells them to do. So if your child tells that attorney, I do not feel I need a guardian, I don't want a guardian, I don't want mom and dad to be my guardian, that is that attorney's job to go to court and tell the judge that. Now, the court-appointed attorney might not agree with what your child is asking them to do. That doesn't matter. Lawyers oftentimes are asked to do things that they personally don't agree with. But it is how our legal system works. Oftentimes in those situations, the court-appointed attorney will turn to the judge or somehow communicate to the judge that they feel it would be appropriate to have a guardian ad litem appointed for this matter. A guardian ad litem is another attorney, usually it's an attorney, whose job it is to determine what is in the best interest. So what's in the best interest might not be what your child actually wants. Those can be two different things. If they are the same thing and the attorney, doesn't feel it's necessary, they usually won't ask for that guardian ad litem. But just so you kind of know who all these different players might be. Also, once you file, an independent evaluation will be scheduled. You'll get a notice from the court saying, so-and-so, Dr. So-and-so is going to do an evaluation at his office. Your job is to make sure the proposed ward is at that appointment. It can be a medical doctor, a social worker, a psychologist. Usually, I believe Judge Clark is typically using a physician to do these. The physician's job is not to evaluate, treat, and offer treatment options and things like that. Their only question that they have to answer is, does this person need a guardian? So they will fill out a little 2-page form for the court. Once that form is returned back to the court, that's when the court will schedule the hearing. And so, that's why it can take 6 to 8 weeks before all this happens. If that doctor initials the right paragraphs that say this person needs a guardian, chances are after that court hearing there will be a guardian that's going to be appointed. So when you get a copy of that report back and it says your child needs a guardian, chances are it's going to happen. If that report comes back and says the child does not need a guardian, then if you still feel they do, you have an uphill battle. It's not unwinnable, but you will have to then present a lot more evidence that this child needs a guardian. This is often the case in mental health issues, because at the time the doctor's evaluating the individual, they might be fine. And so it's hard for the doctor to say this person needs a guardian, because right now they don't. Next week they might, last week they did, but right now they don't.